Everyone can have a seat. It'll be just a moment.
All right, stand your ears in the door. All right, first line. Am I coming down? Yes. Quick.
Everyone can be seated.
Thank you, Judge. Good afternoon. You guys had a good lunch? Stay dry? We're back.
All right.
I like that.
Hold on, Mr. President.
Yes, sir. Oh. Now we're back.
Now we're back.
I want to ask you to do this. Think about this for a second. Those of you that did not raise your hand about any of the special issues regarding this case, in other words, have not come to talk to us already, would you please raise your hand right now? In other words, the people that weren't here talking to us individually yesterday and the day before, those people. Okay. I want to ask you some questions. One of the things that we talked about, and we tried to incorporate this into the questions that we had to those folks that came to see us individually, but those of the rest of you maybe didn't have the opportunity for this. The law provides certain things, and I guess it's important for us to cover a few of them right now. One of the things that the law provides is that somebody that's accused of a crime, which Ms. Schenecker certainly is being accused of a crime, she enjoys a right of absolute consideration of innocence until such time, if it happens, the state puts enough evidence before the jury to change that presumption. She's presumed to be innocent. Now, many of you already addressed this. Many of you already had an opportunity to speak to this, and we asked you about it, and you said what your opinion was about it. I want to talk to the people that haven't had a chance to consider this. This is an absolute legal right. This is not something that I just thought of a few minutes ago, or that Mr. Pruner just thought of yesterday. This is an absolute legal right. It's called a presumption of innocence. Somebody that's accused of a crime is presumed to be innocent. And so as we speak, as we sit here, the trial hasn't started, of course. We're still in the process of jury selection. And so as we speak, Ms. Schenecker should be, by all of you, presumed to be innocent, completely innocent, no reservations, no, well, I think so, or, well, I guess so if they're telling me that I have to, that kind of thing. It's an absolute presumption of innocence until such time as the evidence is presented to the jury, and the jury, upon consideration of that, thinks, if it does, that it overcomes that presumption, and then the pendulum could switch to the other side if that's what you felt as a juror. But for right now, it's very, very important, this initial presumption, this starting place, if you will, is inherent by the law. And again, this is something that's not negotiable, so to speak. If we were out in the street talking about a purchase of a car or something like that, this is not negotiable. This is the law. And so I want to find out is those of you that haven't had a chance to speak to this up to this point, if you have the ability to perceive that, understand it, and accept it, and it doesn't disturb you in some way. Because, you know, people are more likely to probably try to avoid confrontation than to walk into it. And so if there's a possibility that maybe deep down inside you don't like that, you're not comfortable with it, then chances are you'll bring that to the jury duty with you if you happen to feel that way. So I want to know, without reservation, without exception, that you're able to follow the law in that respect, which again is that Ms. Schenecker is presumed to be innocent right now, and that motion is with her throughout the proceedings until such time that the evidence could overcome that burden, if it does. And that's arranged for the jury to decide. That's what you guys would do as the persons that were considering the evidence. So just the people that raised their hand that haven't spoken to this, I want to find out what you think about this legal concept, if you can. I think juror number 9, you spoke to this. You raised your hand a second ago?
Yes, sir.
Do you understand when I'm talking about presumption of innocence? Have you heard the concept of innocent until proven guilty? That's where this comes from, and I think that's probably the more common way that you hear about it, and I think we hear about it in TV and in movies and you know, in normal conversation. But it's called technically a presumption of innocence. Now, are you comfortable with that presumption, and are you able to, without reservation, feel that way at this moment about Ms. Schenecker?
Yes, I am.
Okay, do you have any philosophical disturbance that maybe, well, I don't really think that, I'm just kind of, I know that's the right thing to do as a citizen, I want to do the right thing, but that's really not the way I feel. Are you having any reservations about this at all?
I do not have reservations.
Okay, and what is innocent until proven guilty? Is that a concept I take you've heard that. Have you ever seen application of it before or heard of application of it? I mean, do you understand the principles of it?
Yes.
And you're comfortable with that?
Yes.
Okay, thank you. Who else raised their hand that hasn't talked to us yet that's on this first row? Juror 25, same questions that I would pose to you. I mean, this is what the law says, but I want to know what you really think about it, you know, so that way I know, you know, if you're comfortable with that, because you potentially could be on this jury. You know, we don't know. I mean, you could get selected to be there. Do you have some feeling inside that, well, I don't know, not in every case, I don't think it should be that way. You know, how do you feel about that?
I feel that she is innocent until proven guilty, and if God forbid something happened to me and I was put in her shoes, I'd want the same right granted to me.
Okay. Thank you, sir. So there's no reservations that you have about that? That's a hard feeling you have, a strong feeling you have, and that's something that would not be something that would be causing you any kind of angst or anxiety if you were placed on this jury?
No, sir.
Okay. What about other people that didn't get a chance to speak to this point? I know there's got to be some other people out here, because I know we didn't talk to all of you. Juror 69, did we speak to you about this point?
Not singly, sir.
Okay, why don't you tell us, first of all, do you understand that concept?
Yes, sir, I do.
What's your thinking about that? I take it you've heard of innocent until proven guilty.
Yes, sir.
What do you think about that?
That's the right, I believe in it, for every
Well,
individual.
Would you ever feel that it shouldn't be the case?
It should be.
I mean, across the board, and I'm not picking on you, I'm saying across the board, this is our legal concept, this is the law. I don't care what type of case it is, I don't care what type of charge it would be, it doesn't matter whether it's a jury trial or a non-jury trial, it doesn't matter if it's a big case or a little case, there's still a presumption of innocence that follows with a person that's been charged at the beginning of the proceedings and going all the way through those proceedings until such time as the evidence overcomes that presumption. And that being the law, of course, one of the things that you all would be commissioned to do if you were selected to be on this jury would certainly be to follow the law. And of course, Judge Battles would be able to give you the law, and he'll actually read it to you, but part of my feeling is I like to know ahead of time, just to make sure that I know what your thinking is about this. So you feel you have no reservations about this?
Not whatsoever, sir.
Okay. Anybody else that we haven't talked to? I know there's people. Juror number 32, how are you doing, sir?
Okay, yeah, I've been in here similarly, but we haven't talked about that.
Okay.
But I definitely believe that my son was arrested once and he was innocent and the court system followed too and he was released. Everybody is innocent. I know nothing about anything that I haven't heard here, so there's nothing here that showed me that she wouldn't be.
Right, and I appreciate your comments, and what it comes down to, and this is kind of a big picture, kind of a view of this. We're not here to talk about the evidence right now. This is the jury selection, and in fact, you've heard both of us say this isn't the time for us to talk about the evidence or tell you what witnesses are going to say, or show you pictures, or show you diagrams, or whatever. But right now, it's about finding out if there's anything that you brought to the table with you prior to coming into this courthouse that would cause you in some way or shape or form not to be able to be fair and impartial, not just to Ms. Schenecker. Obviously, I have a very deep interest in her well-being. I'm her attorney. But also to the state of Florida. Both sides here deserve a fair trial. And this presumption is a legal presumption that is enjoyed by everybody throughout the entire country. If you were in Maine right now, or if you were in Wyoming right now, or some other place, and it didn't even have anything to do with this case, but it was another case, it's the same presumption. It still would be there, no matter what, no matter who, no matter what. So I want to know, and I appreciate your comments, would you have any reservations about that feeling about this?
Oh, not at all.
Would you bring anything to the table from prior knowledge or prior feelings about other people's cases that would cause you to, in some way, shape, or form, think that it shouldn't apply in this case?
No, my wife is a college professor and her thing that she did her thesis on was our Constitution and the Bill of Rights. And I'm missing 2 graduations today to be here because it's my civic duty to be here. I'm graduating from college today. And I'm here because this is what needs to be done. It's the only way the system works.
It's true. Thank you, sir. Thank you. Who else hasn't had a chance to speak to this point? I'll try to go in some kind of order, but I may surprise you. If you feel like you're sleeping or something on me, and I'm walking around looking like I'm not looking at you, I'm trying to pronounce it like that. Juror number 39, what do you have to say about this? Do you understand what we're talking about with this presumption of innocence? How do you feel about it?
I believe that you're innocent until guilty.
Do you have any reservations about that where, for example, you might say, well, this is a really serious case. I don't think that presumption should exist now. Or, I don't know about that kind of case. I don't think it should exist there. Or, I'm not entirely comfortable with that. Do you have any reservations whatsoever about that principle?
No, sir.
Okay, so unequivocally, Ms. Schenecker is innocent until such time as evidence could convince you, if it does, otherwise.
Yes, sir.
Thank you, ma'am. Thank you, ma'am. Anyone else that hasn't had a chance to speak to this point? And again, I'm trying to find out what you think. Juror 81, what do you have to say about this?
Can I approach?
Sure.
Thank you.
I think so. Judge, is that okay? Thank you, ma'am. Is there anyone else in that row that I haven't had a chance to, hasn't had a chance to speak to this issue? Juror 83, I don't think we've heard from you about this. Do you understand what principle we're talking about?
Yes, sir, I do. I do understand innocent until proven guilty. I do accept that, and I have no reservations.
None whatsoever.
None whatsoever.
And it doesn't matter to you what kind of case, if it was a little case or a big case or a whatever, no matter where you are, what state you're in, this is a principle you have no reservations about, you're comfortable?
Very comfortable.
Okay. And going along down that same row, with an eye towards people over there just in case. Where are we at? Anybody else that hasn't had a chance to speak to this issue? Juror 86? Yes, sir. What is your thinking about this?
I believe you're innocent until proven guilty. On that, you shouldn't assume anything about anybody.
Have you made any assumptions already about this case?
No, sir.
Would you have no reservation whatsoever about looking at our client and saying, she's innocent right now and forever until, or if, such time comes that the evidence of the case that the state presents overcomes that presumption? Are you comfortable with that?
Yes, I'm very comfortable with that.
You wouldn't have any hesitation or reservation about it?
No reservation at all, sir.
Okay, thank you, sir. As we move down the line, is there anyone else that hasn't had a chance to speak to this issue? Juror 88, what do you think? What's your thinking?
I completely understand and agree to the concept, no reservation.
It gets to be, I suspect, and certainly as an attorney I may have a tilted viewpoint of this, but I suspect that maybe people that aren't in the system every day might have a little bit harder time if the case was more serious or they perceived it, like we talked about this. This is a double homicide charge. There's some, bad features to it. There's some difficult issues that are going to have to be resolved by people in the jury. Does the prospect of it being more difficult or being greater magnitude, does that cause you any pause or give you any reservation in that thinking?
No, sir.
Okay, and you don't have any bad feeling within yourself. You're comfortable with the idea, considering that our client is innocent all the way through the proceedings until or if such time comes as the evidence overcomes that presumption?
No bad feelings. I'm comfortable with it.
Okay, all right. Thank you, ma'am. As we move on now, who hasn't had a chance to speak to this issue as we go down that row? Anyone? Juror 101, how are you doing today, ma'am?
Okay.
Do you have some thoughts on this subject? What is your thinking?
Same as everyone else. Innocent until proven guilty.
Have you been in a situation, I don't remember looking at everybody's juror slip. There was like 250 I to start out with, so I'm not sure if I would remember them anyway, but were you one of the people that's actually been on jury duty before?
Yes, sir, I have.
Was it a civil case or a criminal case?
Criminal.
Did it actually get tried to its conclusion, or were you in this process and didn't get to be part of any other process?
It was tried.
Oh, so because you've been a part of the entire case from beginning to end then.
Yes, sir.
I take it that somebody somewhere during that case probably discussed the idea of presumption of innocence with you then?
Yes, sir.
Did you have any problems with it then?
No, sir.
Did you find that, and of course I'm not asking about the deliberations of the jury, but did you find that this was something that you had reservations about during that time? Did you felt uncomfortable with it at any point?
No, sir.
Okay, and would there be any, when was the last time, when did you have jury duty?
2 years and 8 months ago.
Okay, so I guess closed in on 3 years ago. So now you're here. Would anything have changed your thinking about this concept of innocent until proven guilty? That would, or some special information about this case, or knowledge about it, or the magnitude of it, or the subject matter, or anything like that? Would that get in the way of your application of this process, this philosophy, innocent until proven guilty?
No, sir.
You'd be totally comfortable following the law in that regard.
Yes, sir.
So when the judge says for you to consider that Ms. Schenecker is innocent until proven guilty, you're okay with that?
Yes, sir.
Thank you, ma'am. Did anyone else on that road, have you got a chance, Juror 98, I'll skip over you for a second. Did you get a chance to speak to this point?
No, sir.
What is your thinking, sir?
I believe that everyone should be considered innocent until found guilty, but that doesn't always happen. I can accept the law that they are innocent until proven guilty.
Well, you bring up an interesting point. You say it should, but it doesn't always happen. Do you have specific instances in your mind? And I'm not necessarily asking you to relate everything, but I mean, are there specific reasons why you say that?
Because you have some people incarcerated because they found out.
Okay. Later on after the fact, convicted, that's what you're referring to, right?
Not necessarily on jury. I have been on a jury where there was a murder case. And we came to a conclusion.
Did you enter that jury service with the same presumption of innocence for
Yes, I
the
did.
defendant in that case?
Yes, I did.
Okay, and you were philosophically okay with that at that time?
Yes, I think it should, that's the way it should be.
And you're okay with that today?
Yeah, it should be innocent until proven
Okay,
guilty.
there's nothing that would be different about this case that would cause you to change your position?
Not at all.
And you'd be able to follow the law that says that you should presume Ms. Schenecker innocent at this point?
Yes.
Okay. Thank you, sir. Juror 106, how you doing today? Do you have some thoughts on this subject?
I thought that she was innocent until proven guilty.
Do you have, you've heard of that concept, and so when someone says presumption of innocence, that's what it's referring to. Do you have any reservations about that at all?
No.
Would you have reservations if you thought, for example, the case was really large and important compared to small and unimportant? I mean, you understand, I guess, what I'm trying to get at is that this presumption of innocence would stick with any person charged with any crime. And you're comfortable with that?
Yes, sir.
Would you bring anything to the table, to this particular proceeding as you enter the courthouse to maybe participate as a juror in this case that would cause you to diminish the strength of that feeling inside you?
No.
Okay. Thank you, sir.
Thank you.
Anyone else on that road that didn't get a chance to speak to this subject? As we go to the next row, juror 162. Hello again, sir. You didn't get a chance to speak to this, I take it. What is your thought?
I'm in full support of innocent until proven guilty.
Is that a concept that you ever, how did you apply that principle, if you did, when you were a principal?
From the simplest of cases to the most complex of cases, it has to be that way.
And you're comfortable with that?
Yes, sir. The
And
burden.
it doesn't matter about the magnitude of a case or any kind of circumstances, you're able to be comfortable with that? You don't have any reservations about that?
No reservations. The burden has got to fall on the accuser.
Okay, thank you, sir. Is there anybody else that did not get a chance to speak to this point that might wish to weigh in at this moment? Juror 141, I know we talked to you individually, but I don't know if we talked to you about this. What is your thinking?
I was aware of the law, I understand it, and I assume she's innocent. She's proven otherwise.
Okay. Any reservations about that? Any hesitation on your part? Is there any reason why this case should be different than another case if you look at that principle of the law? Thank you, sir. I think we covered everybody in that row. Is the back row? Juror 169, I know we've talked to you before. Did you get a chance to speak on this particular point?
No, I have not.
What is your thinking about this, ma'am?
That she's innocent until if and when she's proven otherwise.
Okay. Do you have any philosophical anxiety about that?
No, I do not.
Okay. Would it matter to you what kind of case this was? Or does it matter to you what kind of case it is?
That's of no importance.
Okay. So as we speak right now, as you happen to gaze at council table, you're looking at an innocent person right here.
Yes.
Okay. Thank you. Thank you, ma'am. Juror 171, have we talked to you about this?
Not yet.
Not yet. I look forward to hearing, what do you have to say about this? Do you have an understanding of this concept, and how do you feel about it?
I do, sir. I do very much understand that concept, and I believe in any case, no matter what the charges are, a person is innocent until proven guilty. That is the state's burden.
You bring up a very interesting point, which I'm going to try to go to next. Thank you very much. Is there anyone else that hasn't been able to speak as to the presumption of innocence? Yes, sir. Juror 174?
Yes. I believe in the concept. I believe we need it. I have no reservations about it. The burden falls on the state to prove otherwise.
And as we speak, right this second, if you were asked what you think. What do you think about guilt or innocence of Schenecker right now?
I would have to assume innocence until evidence during the case is presented.
Well, she is innocent. That's the presumption. And until such time it comes along that the evidence overcomes that presumption. And so that's why I'm asking you, if you'll have some reservations about this, but you do not. Okay, thank you. Anyone else over there in that row that hasn't had a chance to speak to this point? The point that was made by Juror 171 and alluded to by Juror 174 just a second ago, and possibly some of the others, is that this subject of presumption of innocence kind of moves towards what's next, which is the burden of proof. How do you get from here to there? And the way that you get from here to there, in this case, is by evidence. And a client, my client, or any defendant, anybody that's charged with a crime, is innocent, period. Until such time as the evidence, and it may never happen in some cases, it doesn't. That's how people end up to be found not guilty. That's why people remain innocent throughout the entire process. But the vehicle of this is the evidence. And the one entity, the one place where you look for a burden of proving that somebody's not innocent is with the state of Florida, in this case, the accuser. And that's the next logical stepping point that we would want to talk about, just to make sure, because you start out with the presumption of innocence. Ms. Schenecker is innocent. Right now, period. End of story. That's the law. That's what it says. Well, then you're going to be presented, if you end up being selected to be on this jury, you get presented with evidence. And it's your job to consider the evidence. And that's why we've been very careful to ask you, could you listen to this kind of evidence? Could you look at this kind of evidence? Could you hear that? Have you had any preconceived ideas? Have you already made up your mind, or are you kind of a clean slate? And we've used all these kind of terms for you to try to get it to understand whether you come in here prepared to listen and without some kind of preconceived idea of the way this should work out. And then the evidence comes to your attention. And the evidence can be anything from testimony to pictures, videos. It could be demonstrative. It could be physical. It could be any kind of testimony or any kind of evidence that comes to your attention. Either side's free to give you evidence. And then you listen to it. And then you make up your mind. And only upon such time as you think the evidence overcomes the presumption of innocence, that's when your mind could change legally, when you would have the right to have your mind change. But the one thing that you have to at all times remember, and again, this is not me speaking, this is the law. This is the law, and this is not something that the state shirks either, by the way. They take on this burden. It's that the accusers have the burden exclusively. It's not to this table that you look for proof of innocence. It's to that table that you look for the evidence that would prove guilt. And the burden of proof always stays over there. And so that's the other concept that I don't know if some of you got a chance to speak to. And I know several of you already did. But those of you that have not, that's another legal principle that is not just developed just for this case, just by me, or just by Mr. Pruner, or just by Judge Paddles. This is across the board. This is the way it is. That's what the law is. And so I want to make sure, because obviously, as I said earlier, if you're selected to be on this jury, one of the things you're commissioned to do is follow the law. And so that's what the law says. So this is a matter of me trying to find out, how do you feel about that? So those same hands that didn't get a chance to speak to presumption of innocence, I would say probably you haven't had a chance to speak to the idea of burden of proof either. But let me just pick on somebody to start out with. Juror 171, why don't you please stand up for us? You mentioned burden of proof, I think, in your own comments about presumption of innocence. Do you understand this concept of burden of proof? I mean, obviously, burden means somebody's carrying some of the load.
Right.
What does this mean to you? If I say to you, who's got the burden of proof, what's your answer, and how do you think that?
For me, it would be the state has the burden of proof. They would have to prove that Ms. Schenecker is guilty. But for now, I'm assuming that she's innocent. And the idea is, does that ever shift in your mind? The burden of proof? In other words, the burden of proof doesn't shift. It stays with the state. Correct.
So this is something you're comfortable with?
Yes, sir.
Okay. And obviously, we can bring up evidence. We can show things. We can present things. But the accusation was made by the state of Florida, and the state of Florida is the entity that has the burden of proving their accusation. And that's, I guess, the simplest way to put it. And my question to all of you that had raised your hands to talk about presumption of innocence is that a concept you're comfortable with, so that going into this process, you're not going to be left at the starting gate while the other people in the jury do understand that concept, and you're sitting there saying, well, wait a minute, I have some doubt about this, as far as who's got to prove what. What do you think about it? Are you comfortable with that? Thank you very much. Juror 174, you're another one that stood up just a moment ago and mentioned something about burden of proof. What does that mean to you? And do you understand the idea of who's responsible for it?
Yes, I believe that the burden stays on the prosecuting team and providing evidence to the point that, in my mind, proves guilt beyond reasonable doubt.
Is there anyone here that would expect something different than that to happen? That's the format. Thank you very much, sir. You can sit down. That's the format of a trial. An accusation is made, and there's a presumption of innocence by the person accused, and then the accusing entity, in this case the state of Florida, puts evidence forward to show, if they can, the guilt of the accused person. That's as simple as you can put it. And that's those primary factors of a trial don't ever change. They don't ever change. And so I didn't know if anybody here, would anybody here be expecting proof of innocence from the defense? I mean, again, and I said this a few minutes ago, and I think it was mentioned yesterday too, the defense is free to put evidence on too. The defense is free to put things before the jury. The defense is free to put witnesses up there. The defense is free to make arguments and that type of thing. But who has the burden of proof does not change. It doesn't change. And so that's the concept here that's very important, and I want to make sure that everybody's comfortable with it, because again, you get selected to be on this jury, and you're back there, part of this group that's going to be deciding this case, and if you're missing out on one of these fundamental factors of a jury trial, then you're going to be at a disadvantage when it comes to even deliberating with your fellow jurors. You certainly wouldn't be in a position of feeling comfortable about it or feeling comfortable with yourself. So the question I get to say, I want to, again, ask those people particularly, I don't want to try to go through the whole group because I see a lot of heads nodding that people seem to understand this concept, but is there someone that wishes to speak out on this issue of burden of proof that didn't get a chance to speak to presumption of innocence or burden of proof yesterday when we talked to you all individually? And again, I look to the same hands that just spoke. I mean, for example, Juror 39, how do you feel about this concept of the burden of proof being with the state of Florida in this case?
I believe that's how it's supposed to be.
No, I mean, you're right, it is. Are you philosophically okay with that, or do you have some anxiety about that, or you feel like, oh man, this is a big case, I don't think I should expect that much from those guys, that kind of thing. I mean,
I've served on a few juries before, and I understand the concept.
well, and if you've served in some juries, I bet you money you've heard this before.
Yes.
A little bit of it anyway. I don't know if they put it the same way as I did. Maybe, maybe they did, I don't know. Anyway, this is a legal principle that we're locked into. And so I want to know if you all are locked into it. Juror 101, again, you didn't get to speak to presumption of innocence. Let me get you to stand up again and tell us about the burden of proof. What do you think about that? What are your observations?
It falls on the other side, not your side.
Are you comfortable with that?
I'm comfortable with it, yes, sir.
Okay. Well, I don't want you to get back there and be in a situation that you're not comfortable with, and then it might make for not such a sound decision. So I'm hoping that you are comfortable, and not just you, by the way. I'm not just picking on you. I'm just across the board. Hopefully, if you're potentially going to be on this jury, then you understand some of these starting points, the presumption of innocence, and then the burden of proof, and who has that burden.
Yes, my last case was a murder trial as well.
Oh, good. So you've been involved in that. Then. So, all right. So you may have heard these concepts mentioned before.
Yes, sir.
Would anything change in your thinking from that point to this, as far as presumption of innocence or burden of proof?
No, sir.
Okay. Thank you very much. Anybody else that has any thing to say about this? And again, I want to hear from you. I'm talking too much. I want to find, yes, sir, juror number 4. Did we talk to you about this subject before?
Not of that.
Okay, why don't you share your opinions with us then?
Okay, well, it has to be that way, okay? The burden of proof has to be on the state. And the reason is that obviously our history, people used to be tried with the innocent being proven their own innocence, such as the Salem witch trials and such things. So in a civil society, yes, we have to assume she's innocent. Proof is on now.
Do you feel that somebody's having to twist your arm behind your back to get you to say that, by any chance?
Not at all.
And I am sort of picking on number 4, but not really, because I know that by now, I'm dealing with some pretty intelligent people in this room. I believe anyway, and so I know that by now maybe you all even know some of the things that you could say or should say, that are the right things to say that correspond with what the law says. But how do you really feel about that? I mean, if you're saying, okay, yeah, the law says presumption of innocence, so you better believe it, I'm presuming they're innocent. The law says burden of proof's over there, so oh yeah, burden's over there. But what if you don't really feel it? So I'm asking you to be as honest as you can be. Honesty, just to tell me if that's really the way you feel. And I've just picked on you briefly, but you said that's not the case with you. You say it has to be that way.
Yes.
Okay. Does anybody else? Yes, sir, 98. You may want to stand up just in case.
No problem at all. I agree 100% that the prosecuting team should be on the offensive, that the burden of proof should be on them. But I also believe that if the offense is throwing at you constantly, you got to block it. You just can't sit there and say, I have to prove anything. I'm not saying she has to testify or anything like that, but you just can't let them fire at you, and you say, well, I ain't got to prove nothing. So that's how I feel.
You pick up, you bring a great point up. Thank you, sir. I want to elaborate on that. I'm not saying this is going to happen. I'm not. I'm not saying that Ms. Duncan or Ms. Bradley or myself are going to do absolutely nothing. I'm not saying that, so don't mistake that.
Right.
But what if we did absolutely nothing? What if all we did was cross-examine witnesses put forth by the state, and the rest of the time we just sat here and politely listened, just like you're going to listen if you're a juror? What if we did not go on offense, as you say?
That's perfectly fine. That's your right in that circle.
Well, what I'm getting at is, does that give you, as a juror, the authorization to go ahead and shift the burden and say, well, you guys didn't do anything, so now I got to look at it differently. See, the burden of proof is never going to change from being at that table. And if the defense can or wants to, they put forth things. And again, I'm not saying that we're not going to. But my point, to push it to an extreme, to push way out to the extreme, just to make a point, is what if the defense didn't put on any witnesses? What if Ms. Schenecker never testified? What if nobody testified for the defense?
That's fine.
What if we just sat there? Well, then your responsibility gets to be, the presumption of innocence is still on Ms. Schenecker from the beginning of the trial on until such time as the evidence can, or maybe it will overcome it, or maybe it doesn't. And the burdens for decision based on what you got. You make a decision based on what's in front of you. But, and this is the big thing, the burden doesn't change. The presumption of innocence remains up until such time as it might be overcome, and the burden of proof doesn't switch to this table just because you might like to think, God, I would like to hear from her, or I'd sure like Mrs. Bradley or Mr. Trainer to put on some evidence for me, or whatever. That's not the way it works. And I'm really glad you brought that point up, because some people that aren't in the system every day, they get confused about that a little bit, or they start thinking a little differently. The process calls for the burden of proof to remain over there no matter what, and then you do with it as you wish. If you feel that there's enough evidence, then that burden's been overcome. I mean, that presumption of innocence has been overcome, right? And if you feel like there's not enough evidence, then theoretically, in a trial, and again, I'm speaking now hypothetically just to make a point here, theoretically, an accusation could get made in a trial, and the defendant could choose not to testify, and the defense attorneys could put on 0 witnesses whatsoever, and a jury could still find that defendant not guilty. Why? because maybe the evidence that was put forth by the state of Florida didn't ever overcome that presumption of innocence. So it's kind of that way. And so as a juror, and I know sometimes this is not while we're talking about this, this is great. I'm glad you brought this up. I'm not being critical at all. I appreciate the opportunity to address this with people. But the burden doesn't shift to here just because maybe people in the jury might like for it to. Just because people might like to hear from somebody or something. Or it doesn't work that way. The burden stays over here. And then you're free to consider however you wish. You know? Juror 98 made a tremendous point, and I wanted to address that. Now, having heard me say that, what is your thinking about that? Particularly, again, people that haven't had a chance to speak to this point earlier. Is there anybody here that wishes to speak now about it? You guys were letting me down. I thought you were going to say something. Well, let me ask you this. Okay, Juror 42, do you have what is your take on this?
Well, since I haven't said anything, I too believe that it's up to the state to prove her guilt, and that she's innocent until then. I hadn't said anything, so that's.
I like it, but you know, it's your debut.
I do.
You had a chance to say something today, and I want to hear from all of you though, and I really do. I want to make sure though, and if this could be a show of hands or just nodding, ferocious nodding of heads, like really hard, you know. But I mean, do you all follow this concept? Presumption of innocence, burden of proof over here, and it doesn't ever leave, and that's the way you have to decide the case. Are you all comfortable with that, and do you understand the concept of it? Not just understand it. That's like a teacher saying, "Do you understand this?" Okay? That's not what this is. This is about, you're going to be on a jury, and once we get through talking today, you're not going to have a chance to talk to me again. And I'm not going to get a chance to talk to you again, except possibly just in the forum of speaking to witnesses in front of you. So right now is our time. Right now is it. Right now is our chance to speak together to one another. And so if you have any reservations about these concepts, please, now is the time for you to say so. This is the time for you to make those things known to people so that we can say something about them. We can talk with you about them. So I appreciate all the comments, and I don't even care if they agree with what I'm saying or not. The main thing, I want to know what you all are thinking. Is there anybody else that has a comment about this whole idea of presumption of innocence followed by burden of proof? Now, I think also Juror 98 brought something else up, and that's another easy step in the direction that I'm going. You mentioned, or somebody here mentioned, well, what if Ms. Schenecker doesn't testify, or what if she does? Well, that's a very important thing too. You know, there's a right. Every one of you enjoys a right. If you leave this courtroom, the right is there. If you go home tonight, the courtroom the right is there. If you get up tomorrow and you're driving your car, the right is there. The right is there for everybody to remain silent. There's no compulsion for somebody to have to speak. There's no compulsion that somebody has to testify. And similarly, just like the rights that you all enjoy as citizens, well, Ms. Schenecker is a citizen as well. And there's no demand that the law says that the defendant in a case, the accused and the defendant, must speak. She must take the witness stand. She has to speak. The law says quite the contrary. The law says that she's not required to take the witness stand. Now, she may choose to. Maybe she does, maybe she doesn't. You know, that would have to unfold later. But my concern, I'm always looking at a bigger picture, you know, kind of approach to this. I want to find out what you all think about that, because I want to know what would happen in your mind if you're a juror in this case, and you expect or demand that my client take the witness stand and testify? Are you going to hold it against her if she does not? Obviously, if Ms. Schenecker testifies, whether it be whatever she says, that's fair game for you to consider, just like you would consider testimony of anyone else. But what happens if she or anyone else in the world that's accused was just decided not to testify, or just didn't testify at all? Do you hold that against her because of that? Are you allowed to? First of all, let's start with the law. The answer is no, but now I want to get back to that inner self that you all have. You know, I know what the law says, and you guys know what it is too. That's why y'all are saying it. The law says she does not have to testify, there's no requirement. But do you, juror 15, expect her to take the witness stand and testify? Does she have to satisfy your idea of what is right and wrong?
No, sir.
Who in this room, I think, I'm assuming that everybody here, I know the risk of assuming things, but I believe that from the nodding of the heads and the feedback, that you all understand this concept. What I want to know that I don't know is, how do you feel about it? You know, what do you think about this? Juror number 6, what do you think?
About what again?
What again? And specifically, would you, if you're a juror in this case, would you feel that it's necessary for Ms. Schenecker to take the witness stand and testify?
It's possible. The answer to that question could go either way. It depends if the prosecution is gaining a big threshold on the case and you're running out of options. It could benefit her to try to save her neck by testifying.
Well, I want to say one thing in response. Regardless of what foothold the state might be making or whatever, my question to you is this. Do you, as a potential juror, you could be a juror in this case, are you going to require Ms. Schenecker to take the witness stand for your consideration of guilt or innocence?
Require, no.
Do you expect her to take the witness stand?
The answer that I just gave you would answer that. It could go either way. Yeah, it's too early for me to make that assumption.
Okay, what if I told you that there's under no circumstance ever would Ms. Schenecker be required to testify?
I understand that the law can't force her to do that. But if she's losing in this case and you're running out of ammunition, she might testify again to try to save her neck here.
She might testify, maybe she won't, but if you're a juror, would you expect her to? If you think that she's, let's say your perception is, as you put it, she's losing. Would you expect her to testify at that point?
Yes.
Okay. How many people would agree with juror number 6? Is there someone, juror number 6 makes a point, and I appreciate it. I want to find out if other people agree with that.
Your Honor, excuse me, Mr. Chairman, may we approach? Okay.
I want to go back to you just for a second, juror number 6.
Sure.
Would you, in some fashion or other, hold it against Ms. Schenecker if she did not testify?
No.
Would you, somehow or another, would that weigh in your mind that she didn't testify?
Not necessarily, but it would bring up the question, why would an innocent person not want to testify?
If the judge told you that the law said that nobody's required to testify, can you follow that law?
I understand that, yes.
Can you follow that?
Yes, absolutely.
Okay. What about other people that are here? Number 6 brings up, juror number 6 brought up some very interesting thoughts. How many people feel the same way as juror number 6 does? And I guess specifically I want to find out if the law says that somebody's not required to testify in some fashion or other, or any fashion, are you able to follow the law? That's the first thing. And I see a lot of heads nodding. My second question goes more to your internal thinking. I mean, would you hold that against, because again, I know that you all can say I'll follow the law. That's pretty much of a rote response to almost anything. But what I want to find out is if you personally would be holding it against my client if she chose not to testify. When you're a juror in a case like this, would you hold it against her? Would you find that it would be somehow or another hard for you to be fair and impartial? If, in other words, if Ms. Schenecker decided not to take the witness stand, well, I don't know, I feel so uncomfortable about that. It's just got to be guilty. I mean, what do you think about that?
No.
Is there anybody here that has a sensitivity to that point and feels so strongly that Ms. Schenecker should or has to take the witness stand to explain herself? Win, lose, or draw? Ahead or behind, or whatever, however you want to look at it. Does anybody here feel that there should be some compulsion for Ms. Schenecker to take the witness stand? Is there anybody here that would basically find that they would be biased against Ms. Schenecker simply because she didn't take the witness stand? Bless you. And is there anybody here that would be able to follow the law, which says that someone doesn't have to testify? Is everybody here able to do that by show of hands? Okay, thank you. Sorry, someone raise their hand?
Yes, sir.
Juror 142, I'm sorry, I didn't notice you.
No, I just
Do
want
you wish to speak on this subject?
well, because you had made a comment now, is the time to speak, because I guess you'll choose and then the process starts. So just as a potential juror, I just want to make sure that everything will be explained to us, like any kind of laws. I want to make sure that I'm completely unbiased, and if we have any questions in regards to the law, that they will be explained to us. I do believe in innocence and proven guilty. I do believe in the burden of proof is in the state. I feel that it should be based on the evidence, and there should be no personal opinions put on it. It should be based on the evidence that's provided to us. And so if there's factual things that we may want to know about the law, I want to make sure that we can't ask of it, because just since you said this is it, so I'd rather get it all out in the open.
Oh, no, I appreciate any questions that you have along those lines. My simple response to that is that when it comes to the law, Judge Battles is going to be telling you what the law is.
That's what I just want to
Every step of the way. He'll give you some instructions about how to deliberate. He'll give you instructions on how to weigh the evidence. He'll give you instructions on all sorts of things during the trial. That's what the job of the judge would be.
I assume so, but since you said now's the time.
No, that's a great question. I mean, if somebody's not here every day in this kind of system, maybe they're not familiar with that. So I would answer that to everyone. If you are selected to be on this jury, you're not going to be presumed to have a law book in your hip pocket and know everything that there is to know. The judge will tell you all of the law, and he'll tell you the rules. He'll do that. That's what he will do.
Okay, perfect.
We don't tend to get into that in great detail right now, simply because we're at a different stage of the proceedings.
I didn't want to wait till late, till you said now's the time, so I thought.
That's fine, that's fine. Does anyone else have any questions about those principles? Again, we've talked about presumption of innocence, burden of proof, whether Ms. Schenecker is required to testify or not testify. Is there anybody that wants to have any further input or have any other comments about any of those subjects? I want to ask, I just want to make sure of one thing. I think this may have been asked, but possibly in a different way. I don't know. I want to just make sure with this group that we have here, on or around back in the beginning of 2011 is when this took place. This incident that we're discussing will be the subject of the trial. I want to know if during that time anybody had any personal connection to Benito Middle School. This is along the lines, by the way, there's no mystery here. I mean, both Mr. Pruner and I have read some names to you, potential witnesses, familiarity with them or knowledge of them. So it's the same kind of thing. I want to find out about the area. Did you have any personal connection to Benito Middle School? Anybody in here? How about King High School? And again, I'm dating you back to the beginning of 2011 when this incident took place. King High School here in the Tampa area. How about Liberty Middle School?
Say that again.
Liberty Middle School.
Both my daughters went there.
Okay, I think you had said something about that.
Yes.
Okay. And I think you explained the circumstances that, and you actually talked to them about some of this related to this?
Yes.
And you told us that individually, correct?
Yes.
Okay, I remember that. Is there anyone else? Juror number 135, yes, sir?
I graduated from King High School, but you're talking about as pertaining to 2011?
Correct.
Okay.
Correct. And you look like you may not have graduated in 2011. I'm just kidding with you. But anyway, would you have had any connection to King in the area of January 2011?
No.
Okay, thank you, sir. What about the Tampa Palms neighborhood or the Tampa Palms area? Anybody lived there at that time or had any close friends or were aware at the time? Aside from you, because I know you talked to us about that also. And again, right now I'm kind of in a situation where I don't remember exactly who we've already talked to about this, so I'm just checking. Anybody related to the Tampa Palms? And yes, sir, 135?
Well, yeah, my fiance, her mother lives there, so we go over there every Thanksgiving.
Do you remember whether or not you became aware of anything related to this case back in January 2011 as a result of any connection between your fiance and you with the Tampa Palms neighborhood?
No.
Okay.
Whatsoever.
Well, that's what I'm getting at, just to see if you had any familiarity with this.
Right, no.
Thank you, sir. Oh, there you go.
One thing I just thought of, my wife now, but I wasn't really involved back then. I believe her daughter graduated from King in 2009, I think, or 2008, but I didn't even know her then.
Okay, so there wouldn't be any connection.
Not that I
Certainly none of your-
I didn't even think about it till just now.
Okay, all right, thank you, sir. Is there anyone else? It's probably a shock to you at this point, having heard the remarks of Mr. Pruner yesterday and also my earlier comments, and having listened to the potential witnesses that might testify in this case, that this is a case that could involve mental health issues. In fact, you've been given a series of questions that relate to that, and I want to address those with you at this time as well. I want to find out, and again, I'm trying to find out what your opinion is about things. I want to find out what you think. And so I would ask you just to give me a general idea. Some of these we've already asked some questions that are related to this, and some not at all. I guess my first opinion, or my first question is, what is your general opinion? Do you have a general opinion regarding mental illness in our community? Is it there? Is it not there? Do you see evidence of it? Do you have any connection to it, or are you affected by it in any way? And I would take a show of hands, just if you wish to speak to this subject and tell me what you think. You may not have any opinions about this, which is fine, but maybe you do. What do you think? Juror 23?
My mother her stepmother is bipolar, and basically kind of dealing with her and my father and watching that whole situation of being on the medication and not being on the medication, of how much of a big swing there is. So it's just being able to watch her and watch her function on the medication and able to lead a normal life, and as soon as she stops the medication, how bad it turns.
Do you have a feeling about whether or not the observations that you've made with your situation, would they, in some fashion or other, cause you to have some type of inherent bias or prejudice in one way or another regarding perhaps mental health testimony if you were to hear it in this trial?
No, sir.
Do you have any opinion regarding whether mental illness is common in our community?
Absolutely it is.
Do you have any opinion regarding mental illness, regarding whether or not you would be more inclined or less inclined to accept that mental illness could be a factor in a case such as this?
I just have to look at the evidence that's put forward and go off the evidence that there is.
So if I could take the liberty of inferring, then you don't have an opinion for or against either way, but you'd have to listen to the evidence.
Yes, sir.
Okay. Who else would wish to speak about this in terms of your own opinion about it? You could potentially be on a jury that, in this trial, it seems like maybe that's going to be a factor for you to consider. So what do you think about that? You know, is it something that you can do, or something you feel comfortable with, or something you just feel totally uncomfortable with? And maybe why? What do you think?
Well, so
Juror 98?
Yeah, you just mentioned that mental illness might be a factor in this case. It wouldn't be a problem for me, but just because you're mentally ill doesn't mean you have to commit a crime. There are many mentally ill people that don't go out and commit crimes, so I don't know. I mean,
Well, I'm asking for your opinion, that's fine. I just want to know if you...
It can go either way.
Excuse me?
It can go either way,
Right.
depending on the evidence.
Right, okay. My question to you would be, does your knowledge or your opinion about mental illness, would that cause you to have some bias or prejudice in favor of one side or the other in this case?
No, I just feel that it can go either way. Being mentally ill, like I said, doesn't mean you have to go out and commit a crime. You can do good, you can do bad. I've seen mentally ill people do both.
Well, yesterday, thank you very much, sir. Yesterday, Mr. Pruner even went so far as to kind of give you an overview of the instructions or what it required to consider insanity. And I remember he told you some of the factors, and you guys asked some questions about it. You all remember that? Yes. My question to you is this. Is there any, I want to know if you actually could consider, and I think many of you answered this question yesterday in the affirmative, but I want to find out, is there anyone here that would be unable to consider insanity as a defense to a criminal act, to an otherwise criminal act? Anybody that just couldn't do it? Maybe strong feelings about insanity, for one reason or other, not to be critical in any way. Just, what do you think? Is there anybody here that would be unable to consider insanity as a potential defense to an otherwise criminal act? Juror number 10. Do you have an opinion about that?
My opinion is that if an expert in the field can convince me that insanity was a factor, then it would have to be considered with all the other evidence.
Okay. Juror number 27, what do you think about that? Do you have an opinion about what I just asked?
No, I believe insanity is a plea. That you can plead, you can be so insane that you do something.
And would you then be able to consider, if the evidence supported it, I'm not telling you to just come out of nowhere with it, but if the evidence supported it, you could consider that as a potential defense to an act?
Yeah, if the evidence supports it, yes.
Would this be something you would have reservation about, or would you be comfortable in taking that?
I would be comfortable.
Juror number 4, what about you?
Yes, no, I'd be, if she is found, or through the evidence, it's proven that, in my opinion, that, she was, insane at the time of the crime.
And that's a distinction that was made earlier, and I'm not debating that with you. I'm just saying that it's there, the evidence is there.
Oh, yes, it would be a viable defense.
What do you think, juror number 6?
Well, it seems to be so much emphasis put on this, it's almost like you're heading us in that direction. The answer to the question is I wouldn't have any problem with entertaining the thought of insanity. I would have no problem.
Have you had any observations or opinions about mental health issues in the past as it related to you two or affected you in your life?
It's never affected me, but I've seen a lot of people with disorders.
So to you, view mental health and mental illness as a viable situation that exists in our community. And I'm not suggesting that anyone likes it or that it's popular. It certainly isn't something, hey, we have a lot of cases of this in our community. You know, that's not like that. I'm just trying to determine whether it's something you realize is a viable or consider a viable entity.
Yes.
And whether you can consider that as a potential, as a viable defense.
Yes.
Juror number 9.
Yes, I definitely think that that would be a reason for crime.
Do you have any, and I don't know, I don't remember whether we had a chance to talk to you or not. I don't think so. I think that's why we were talking about presumption of innocence with you earlier. But did you, do you have any observations or any ways in which mental illness or mental health issues or insanity, for example, has that touched your life at all? People that you know or have heard of?
I don't have any close friends or family. Co-workers I've seen. I do believe it exists. I do believe in chemical imbalances and medication for that, but I do not have it close to me.
Okay. Okay. And I'm not suggesting that you have to make a decision. In fact, maybe sometimes it's better that it's not close to you. But I just wanted to find out if you would consider that that's potentially a defense and whether it exists, whether you acknowledge it. You feel like you're comfortable with that?
I am comfortable with that.
Okay. And I think juror number 10, you already spoke to this. What about you, juror 14? I think with your background, you may have already spoken to this as well, as a matter of fact.
I do consider it a viable defense. And again, I would have to just wait for the evidence to, and you know, I don't have a problem with it at all.
I would like to talk to each and every one of you about this, but I want to get some idea. First of all, how many people agree with, I've talked to jurors 4, 6, 9, 10, 14, and you all have heard their feelings about this. How many of you all agree with those feelings? How many, by a show of hands? Let me ask it differently. How many people do not agree with that position? Don't feel that way. Because I might like to talk to you about that. Did you have your hand up, juror 57? 42, how are you on this subject? What do you think?
I agree with the as a viable defense, but I just have to be convinced. You know,
Well, it has to be there. You have to feel that it's there.
It definitely has to be there, but I would have to weigh the evidence.
Well, let me ask you this. Let me put it to you in a lawyer kind of way. Would you be in a position where you would say you would never consider insanity as a defense, no matter what?
No.
Okay. So then I would take it that you could consider insanity as a defense if you felt that the proper circumstances were present?
Yes.
And again, just as I said earlier, this is for you, Judge 142, among others, but the judge will tell you what the law is on all of these concepts. This is not something you have to debate in your mind. I mean, he'll tell you what you're looking for if it's there. It'll be there. The law will be there. But assuming that the criteria is there, are you comfortable to acknowledge that it could be considered as a defense?
Yes.
Okay. Juror 53, I don't think we've talked. What is your opinion about this?
I feel the same as the others. Insanity can definitely be a factor. Then again, it could be something totally new that we don't know about yet.
What do you mean by that, sir?
Well, that's what I'm saying. I don't know exactly what was going through her, step by step, what happened at that point. We don't know. That's why, everybody's mentioning the evidence. That's what we're going to have to move on.
Right.
The facts.
Okay, would you be willing and able and prepared to listen to testimony and evidence from people to learn those kind of facts?
Yes, I would.
Okay, would you have any reservations such that you would never be able to consider insanity as a defense?
No.
Okay. Juror 62, what is your opinion about this?
I strongly believe that, lost my thought. Can you go ahead and repeat for me?
Well, I was asking, what is your opinion? I've asked if you had an opinion about mental illness or mental health issues being common in our community, and would you be able to consider insanity under any
Yes,
circumstances
I
as a
firmly believe
defense?
insanity as a defense. That was
Okay.
my thought before, I just lost it, sorry.
Okay, that's all right. Do you have any ways in which mental health issues has touched you or your family in ways that you've been able to observe close up?
No, sir.
Okay. Juror 66, is that you? I couldn't see the other number. I don't think I've had a chance to talk to you yet today. Good afternoon. You're trying to hide the number on me, right?
Maybe.
What do you think about this?
Accepting the insanity as a proof?
Yeah, could you ever, under any circumstances, consider insanity as a defense if you thought it was there, if the evidence was there?
I work with children that I was abused in the Child Abuse Council, and I have a child that a mother hit him so hard that he had to be covered with this. I don't know what it is, but they brought it to me and I have to help him to keep in the school, and I know that it can happen anytime, any moment. So it's possible to be accepted.
So you think it's possible that someone could have mental health issues that could rise to the level of insanity as a defense?
Yes, it can.
Provided, of course, the evidence is there.
Yes, it is there.
Okay. Juror number 71, I haven't had a chance to talk to you yet this afternoon. How are you doing today? I remember you making some comments about your past history. Do you have would you weigh in on this subject? Do you have an opinion?
I do believe that insanity is a real defense. But I would have to also look at all the evidence and get a good feel for what was in what led up to the incident.
So you could consider insanity as a defense, but you'd like to hear the evidence. That's not a problem. Do you have any opinions other than that about the subject of mental illness? Have you, I guess you've seen some examples of this in your work, right?
In my work?
Or in your background?
In my background, yes.
Yeah. Okay. Juror number 72, what's your opinion about this?
She pretty much summed it up. I do believe there's plenty of insanity in the world. I'm surprised there's not more, actually. But it would have to be proven that it can be used as a defense if it's proven.
Juror 34, do you agree with the opinions that have been stated so far, or do you have a different opinion?
I do believe that someone can do something and be totally oblivious to the fact that they've done it. My wife, she sleepwalks, and she do some things at night that she's not aware of. I try to bring it to her attention the next morning, and she has no clue that she done it. So yeah, I do believe people can do things and totally be unaware that they've done it.
Would you be able, if selected to be on this jury, to listen to the evidence to see if there was competent evidence to support insanity as a defense?
Yes.
Would you have any reservations about that?
No.
Juror 57, what do you think about this? I'd like to hear your opinion about this. What do you think?
If it's presented to me in such a way that I believe that there was insanity involved at the time, right and wrong type of thing, and then it would deserve a strong evaluation, and I find that and prove that was the evidence that was presented to me showed it.
You'd be willing to make Do you have any criteria, if you were placed on this jury, if you were selected to be in this jury, would you be able to listen to the evidence to hear whether, in your opinion, it supported such a defense?
Yes, sir.
And if it was there, would you be able to consider it as a defense?
Yes, sir.
One of the reasons why I ask this question is because if you stop to consider the subject of insanity, it seems kind of like a nebulous kind of thing, and people sometimes appear on juries to be uncomfortable with it. If you, is there anybody here that would be? Let me ask it this way, and I'm going to present you with a case, and it has nothing to do with this case, but I'm going to a hypothetical example. If you were on a jury and you listened to evidence and you were convinced and you felt that the evidence supported insanity as a defense, would you be able to acknowledge that? Or would you still have, for other reasons, some reluctance to acknowledge that? Is there any other reason, anything else running in your background or in your mind or your opinion that would cause you to be reluctant about finding that there was insanity if the evidence supported it? That's the hypothetical. The evidence supports it. Of course, if you get selected on this jury, you'll listen to the evidence. Either it will or it won't, let's say. So I'm not talking about that right now. I'm just throwing a question at you. If you were listening to evidence and it did support insanity, would you be able to consider that and acknowledge that defense, or would you feel uncomfortable or reluctant for other reasons? Think about that for a second, and I'm going to pick on somebody to see what they think about that, because I want to find out if this is something you could. Juror 139, if you could stand up, please. I see you, I know you're in thought, and I can't tell if you're shaking your head, no you couldn't, or you're just thinking you're serious about it. I understand that. What is your thought, sir?
I'm still thinking about it. I'm not sure. I guess my reservation or my thought train right now is somebody can do something, get found or plead insanity as their defense, but I don't see where where you're absolved of what you did because of X. I look at it, I'm looking at it as, you did this, and maybe it was because of this, but you still did this. So, to segue into that as a reason for what you did, I don't know, just have reservations or thoughts about that.
Well, I appreciate your comments. If you were in that situation, and let me push it to the extreme, like I like to do just to see what you really think. You're on a jury, and you hear evidence that completely convinces you that the person that was accused is insane. Completely convinces you. Would you still have reservations about a not guilty by reason of insanity resolution of that case because of the other thoughts you just expressed to us?
Right now, I'd have to say
You believe so?
Again, if I did something, I did it. But because, I can say I didn't take my meds or I didn't do something else that caused me to do what I did. So, I'm not responsible or going to suffer any ramifications because of my actions.
I think I understand what you're saying, and you're looking for some absolution which you don't find out of an insanity defense. But let me ask you this. Would you ever, under any circumstances, be able to find somebody not guilty by reason of insanity? Based on your thoughts that you've expressed to us?
I think so. I'm not positive.
But you would have a lot of reservation about it. And it's because you're looking at the fact that you can't see absolution for the incident Is there anything else that gives you pause to have reservation? Any other aspect of it?
I don't think so. Just because, we all got up this morning and chose what we were going to put on to wear. You make decisions, you take actions based on your decisions, and, I understand, I travel quite a bit for the area I go to work, and I see mental health issues every day on the street, and, I'm sure that there's help there, whether they want it or not is a different question. But again, you do something, and right or wrong or indifferent, it's there's consequences for everything. And I don't know. I just have reservations about being able to say, okay, yes, you did it, but it was because of another reason that you did what you did. I come back to the fact that you did, what you did. So I guess the problem I have there is the not guilty part. Yeah, you did it, but I'm not guilty because I don't see anything.
Okay. Let me ask you one thing, and I think I understand what you said, and I'm going to ask you to sit down in a second, but I do want to ask you another question. You brought up a point that I want to follow up on. Are you concerned in any way with your general reluctance, which you stated to us, about insanity and the potential for not guilty by reason of insanity? You said something about consequences. Are you concerned about consequences? Or lack of consequences, or however you might want to look? Is that something that is part of your opinion as you're stating it to us?
Yes.
Okay, thank you, sir. Thank you very, very much. I appreciate bringing some points for consideration. I hope you all were listening to Juror 139. I want to find out if there's other people that agree with him. If there's people, and this is not if you do, please raise your hand. This is a tough subject. This is not easy. So I want to find out, are there other people in this group that agree with Juror 139 about his assessment? He expressed that he would have reservations about insanity and not guilty by reason of insanity because of the lack of absolution and his concern for consequences. Is there anybody else that feels that way? Juror 71. What is approach? 139 and Juror 71 raised a couple of good points, and Judge Battles will read you some law regarding the subject that might be able to help you in answering these questions.
All right, now, ladies and gentlemen, I'm going to present to you a portion of a legal instruction dealing with the issue of insanity. I'm only going to read a portion of it. It's a much longer instruction, but relevant to your discussion right now, and I'll read it. If your verdict is that the defendant is not guilty by reason of insanity, that does not necessarily mean she will be released from custody. I must conduct further proceedings to determine if the defendant should be committed to a mental hospital or given other outpatient treatment or released. That's the pertinent portion of that instruction that I want to read to you. And now, having read that, I'm also advised that a number of you have indicated that you are in need of a break. So we're going to give you a 20-minute break. I'm going to remind you as you go out not to discuss this case or what we're doing in the case, the questions, the answers, the process itself, not to discuss it among yourselves, not to discuss it with anyone else, not to allow anyone to discuss it with you or in your presence. Recall that the instructions specifically provide you not to read or listen to reports about the case from any source whatsoever, not to speak at all with the attorneys, any witnesses, or the defendant about any subject to deliberation or not to gather information about communicate or the people or places of operation or means, including all those electronic devices. With those instructions, we'll send you out for a break. All right? Panel's actually recording.
Just we're going to excuse the reading one that we've already excused the cause of this one.
I'm reading one on motion at bench by counsel for the defense earlier without objection from the state after hearing responses to questions excused for cause.
I would move for cause in addition on juror number 71 based on her responses at the bench.
Thank you for the time. For this and for other considerations, some of which were previously known by the court, the state is not opposed.
Mr. Number 71 on motion of the defense without objection from the state, should be excused for cause.
And move to strike juror number 139 as well. He had a problem with there not being any consequences no ramifications. He's not positive if he could consider insanity because the problem is not guilty.
I think at this juncture, with following the judge's instruction just having been read, I think the inquiry is incomplete. I don't think he was aware of the law at the time. I don't think it was entirely explained to him at that time.
Well, to be frank, counsel, when we have questions such as that are in the absence of law and where they are under a clear misimpression, it's very difficult to make that determination.
I tend to ask him some more questions after you read the law.
Okay. All right. I'll reserve on that, counsel. You can raise that again. Any others?
The other one, Your Honor, would be juror number 6, when he was discussing Ms. Schenecker's right to remain silent. He indicated that that would be tough for him, and he also indicated why would an innocent person not testify.
With all due respect, that's a mischaracterization of what he said. He indicated that he indicated repeatedly that he would never require her to testify, that he would not hold it against her if she didn't testify, but that his thought process might be if the evidence is overwhelming and proving her guilt, he could be thinking, why wouldn't an innocent person testify? That's not a disqualifiable thought. He nevertheless did not indicate that he would in any way not be unable to afford her or follow the law concerning not taking into account or requiring her not to testify.
Anything else?
No.
I must say the body of his responses there, including, well, perhaps interwoven the way counsel indicates in his overall analysis, again, somewhat confusing presentation and his response, but the overall body of his response does cause the court to have a reasonable doubt of his ability to be fair and impartial and to comply with the law concerning the Fifth Amendment. I'll grant the motion of the defense as submitted. Nothing further from the statements.